Hello, everyone. We haven't talked about the law before on this podcast series, the relationship between the law and complex systems. Well, in this episode, we are joined by Michal Shur-Ofry, a lawyer and an associate professor at the Hebrew University Law Faculty in Jerusalem and a visiting faculty fellow at the Information Law Institute at the NYU Law School. Now, Michal is going to talk about the fact that many of the systems we try and regulate using the law are in and of themselves complex systems. What this means is that if you're trying to apply the law to that system, you better understand some of the concepts of complex systems, many of the concepts that we talk about on this show, like networks and self-organization. Because if you don't understand those concepts and you instead take a very Newtonian or linear way to try and regulate a system, you're probably doomed to fail. If that isn't interesting enough, what is really mind-bending about the conversation to come is that you're attempting to regulate a complex system using the law, which is in and of itself a complex system. So we're in this really strange situation of a complex system trying to regulate another complex system. Michal, welcome to the show.
Thank you. Glad to be here, Sean.
So you're a lawyer who became interested in complexity science. How did that happen?
So I was writing my PhD in law. This was about 15 years ago. And the topic was iconic works that are protected by copyright law, such as the Statue of Liberty, or I Have a Dream speech by Martin Luther King, or Mickey Mouse, or Barbie, and also technological standards like Microsoft Windows. And I started digging into the process of popularity. I was asking myself, it's really interesting why these particular works became iconic, became standard, became something that everyone knows. And this led me to the literature on success, on preferential attachment, on networks and interactions. And one thing led to another, and I found myself completely immersed in the science of complex systems. And then I realized after completing the PhD that these insights, which I sort of delved into, were very relevant to other areas of the law, not just copyright law and not just intellectual property. And this is how it began.
So fundamentally, why does complexity apply to the law? What does it have to do with it?
Okay, so maybe the key insight, just in one sentence, the elevator pitch is that the law seeks to regulate systems, and in order to do this, it has to understand these systems, and complexity provides insights about those systems. But I agree with you, what you're alluding to, that the connection is not so obvious or not so intuitive to many people, because outside the legal field, people tend to think about the law as something external and fixed, something that we just apply, a set of rules that we apply to society. And inside the legal field, sometimes people tend to think about complexity as just something complicated. But actually, both of these perceptions are inaccurate. First of all, when we speak about the law, it is not only this body of rules and regulations that we all need to abide by, but it is also a tool for promoting social goals. Like in legal academia, we call it a tool for social engineering. So, for example, we provide patents in order to encourage innovation, because innovation is important for society. We can apply tax incentives in an effort to reduce environmental harms, because we want to protect the environment. And we can regulate online platforms in order to mitigate the problem of fake news and misinformation. So this aspect of the law. In all these cases, the law aims to influence systems, right? The social system, the internet, online platforms, the environment, the economy sometimes, and all those systems are complex systems. So in order to do this effectively, the law, and I speak here of the law in a very general jurisprudential sense, not specific law, the law needs to understand how systems works, and complexity provides this understanding. And on the other hand, if we lawyers think of complexity just as synonymous to something complicated, then we lose all those very scientific and robust and solid insights that the science of complexity can provide today on how complex systems behave, what do the macro dynamics look like, what are the common traits like self-organization, the temporal and spatial diffusion patterns that they follow or often follow, their nonlinearity, their adaptability, etc., etc. And we can also, when we are familiar with these body of science, we can also make use of the methods for empirical studies like network science, like agent-based modeling, like mathematical diffusion models, in order to design more effective law. So in general, from a bird's eye view, this is the connection.
And would you say that the legal community, worldwide, takes a good view of systems that they're complex, or would you say that it's more of a Newtonian simple approach or a complicated approach? How deep do you think this understanding of complex systems is for lawyers or policymakers trying to drive change in these systems?
So I think that traditionally, what I think you're implying is correct. That the basic view of the law and also of legal scholarship is rather reductionist. We assume that if we get the right set of rules for one individual, we would concentrate on individuals, and we assume that if we get the right set of rules and incentives for an individual, then in the aggregate, this result will be the right set, or will be the desirable social result. So we do not pay much attention to interactions, to nonlinearities, to things that happen in this transition from the micro to the macro level. But I have to say that I do see increased interest and engagement with complexity in recent years, on behalf of not just of academics, but also policymakers and even judges. So I am hopeful that this view will become a very established and natural view and toolbox for lawyers and policymakers.
So one of the things, I think any of us who are involved with complex systems are really interested in is that, you try and influence the system to behave in a logical, sensible way. But because we don't treat it, well, because it is a complex system, it can do very strange, weird things. Is there any really interesting, shall we say, failures of policy that have produced really bizarre results that nobody expected, but seemed really sensible at the time?
Well, one example which comes to mind is how the law views or should view exponential diffusion. Because usually when we try to regulate social harms, the law often thinks of the harms in a very linear or stable way. So, for example, and from this, we derive certain principles on how regulation should be done. So, for example, we have a very basic principle of proportionality, which exists, I think, in most, if not all, Western legal systems. So we want to prevent harm. We can impose some limitations on individuals, but the limitations have to be proportionate to the harm we want to prevent. So, for example, if you want to prevent road accidents, we can impose a duty to wear seatbelts in cars. this would be proportionate, right? But if we just say, okay, we prohibit all private transportation, this would not be proportionate and would probably be illegal if a state regulates something like that. And this makes sense, of course. But when we society face phenomena that are diffusing exponentially, as sometimes happens in complex systems, as happened, for example, during the COVID pandemic, these regular tests may not be so effective. So, for example, suppose we want to prevent a pandemic that starts spreading, and we apply very strict measures like border closure. If we apply border closure during the first day of the pandemic or the first week of the pandemic, when we have only 3 infected cases in a country, then perhaps we can be successful in curbing a pandemic. This is what New Zealand did during COVID. But if we apply the regular test and we say, okay, let's apply the least restrictive means, and only if this doesn't work, we will apply stricter means. So let's wait with the strict means. And the phenomenon diffuses exponentially, then applying the border closure 2 months later, when we have dozens of thousands of infected cases in the country, is ineffective. So in these cases, if we understand that we have the complexity mindset and something diffuses exponentially and quickly as the pandemic diffuses, it may make sense to adapt an inverse proportionality test. So apply the strict means in the beginning, but applying the same means later may be disproportionate and illegal. So this is, I think, an example where the law does not always grasp the dynamics of complex systems.
And that's fascinating, isn't it? Because it's a very linear approach, proportionality, and it's yeah, a linear relationship between cause and effect, and as we know, obviously, in complex systems, that is a real diversion in terms of behavior. Wow.
I
And one of the I recently spoke to some judges about complex systems, and the question they asked me very specifically was, how does a knowledge of complex systems assist good decision making from a judge's perspective? Because if we like to say with linearity in decision making, I mean, by taking a complex systems view, we're really throwing something quite new into the field and saying there's lots of interacting parts. So how does the law cope with that?
So, I don't think there's one general answer to this. I think applying the lens of complexity to each distinct legal question and field could be different, and this requires a lot of work. Hopefully, a lot of people in academia will also, jump on this bandwagon and do this work in the future. But in general, I would say, first of all, we have to remember that the law itself is a complex system that tries to regulate complex systems. So it is a complex system because
Wonderful.
it is, yeah, it is, especially the common law where cases cite each other. So we have a case citation network, and we have, of course, networks of citations of academic papers and sometimes regulations. The legislation itself refers to previous regulation. So, and there are empirical studies indicating that this system has the traits of complex system. For example, we have hubs in the case citation networks. These are cases that are highly cited. We have clusters. There are analysis of case citation networks that demonstrated that these networks are clustered. So cases, for example, from the same legal area tend to cite each other. So the system itself is a complex system, and then it attempts to regulate those other complex systems. Now, one thing that we should keep in mind, I think, is the adaptability, the nonlinearity of those systems that we're dealing with. So attempting to just design very, very detailed legal rules that attempt to anticipate every possible scenario, I think is not is an approach that to a large extent, is deemed to fail, because the law itself as an institution has to maintain this adaptability, this responsiveness to the nonlinearity and predictability of the complex systems it's dealing with. So what does it, how does this translate
Yes.
to legal to legal policy? So one approach may be, let's use in some cases broad and flexible standards instead of very, very detailed rules. Or let's try to think about adaptive regulation that would be responsive. So that would let's try to construct our systems in a way that would gather information about the effect of legal rules and then adapt accordingly. Now, of course, all these are not easy to do. And also, there is value in predictability, in stability in the legal system. So, I don't want to simplify things here. There are no magical solutions, but I think this is one understanding that judges should keep in mind. I can say that the Israeli Supreme Court, for example, during the pandemic, one of the judges relied on work on a co-authored work of me and my colleague, Professor Malkei from the Hebrew University, and used the insights from complexity to justify a precautionary approach in one of the cases that reached the court concerning the diffusion of the pandemic. So there are specific places where judges can use those insights, but also policymakers and legislators.
So I really like the concept of a complex system trying to regulate or control a complex system, and the idea of rather than having highly prescriptive laws or rules that can't anticipate how the system's going to adapt. Um, is there good examples of where we got it right in terms of having broad enough laws that were able to cover the adaptations of the system we are trying to regulate?
Well, I can get, there are, of course, examples of broad rules or broad concept in law, broad rules or in concept in law. For example, the concept of reasonableness, right? Reasonable is a very broad concept. The other side of the coin is that it is also an ambiguous concept. And in common law systems, part of the work of the courts is trying to clarify what is and is not reasonable. I can give you another example for how courts can use insight from complexity, from intellectual property, from patent law. So patent law uses the concept of non-obviousness or inventive step in Europe. So in order to receive a patent, the invention has to be not obvious relative to what was before. So you have to convince the court, the patent office, in some cases also the court, that the invention embodies a technological step that is not obvious, and the concept of obviousness is ambiguous, and the decision what is and is not obvious is a difficult decision, especially for non-experts, but also for experts. And in many countries, the courts developed a rule to aid in this decision, according to which commercially successful inventions are deemed non-obvious and deserve patent protection. Now, of course, if we look at this through the lens of complexity, complexity tells us a more complicated, more intricate story about commercial success, right? We know that the relations between intrinsic qualities and market success are nonlinear. We know that they are very sensitive to initial conditions. Even one like or one adaptation at the beginning of diffusion can make a huge difference in the eventual success of an object diffusing in a network. We know that success is amplified by preferential attachment, Ritchie effect. So altogether, we we can understand that success is not a very reliable proxy for technological ingenuity. So perhaps we should think about other tests when we try to evaluate non-obviousness of inventions and to decide which inventions deserve patents. So here complexity can help too, because patents are registered with patent offices. And in order to register a patent, the inventor and also the patent office cite previous patents, right? Cite the patents that preceded the invention in order to be certain that the invention is indeed new. So these citations of previous patents create a patent citation network, which attests to the relations between inventions. And this patent citation network is highly studied by economists, by people from management science, by lawyers. And one of the very interesting insights emerging from this body of literature is that the patents that are highly cited, so the patents that are highly cited probably represent impactful technologies, maybe sometimes even breakthrough technologies, because many subsequent technologies cite them, so relied on them, mentioned them, are related to them. So those highly cited patents themselves, in their backward citations, in their citations to previous patents, often cite to patents that did not appear together before in a single invention. So they connect, this implies that they connect technological building blocks that were not connected before. So this connection between technological building blocks is a proxy for inventiveness, for technological ingenuity. So we can use this insight in patent law and use this structural trait of citations to patents that were not cited together before as an indication for the invention's non-obviousness. So here, complexity can provide us, I believe, a test or a measure, a metrics that is more accurate than the current metrics used by many label systems.
And does that mean that if you have two patents that don't appear cited together in the past, that attests to their inventiveness because they didn't appear together? They are unique.
If there is a third patent that cites those patents, that's a new invention that says I rely on this on invention A and invention B, but A and B never appeared together before in a single
Ah,
patent.
yes.
Then the new patent, this interdisciplinary invention that connects these previously distant building blocks,
Is new.
is new or is not obvious, or at least this is an indication that it is not obvious. This is the idea. It's reminiscent of the concept of between centrality in network analysis.
Yeah, and we said we had Matthew Jackson on talking about between the centrality before in the show. I mean, that's really interesting because it's using complexity science, isn't it, to say that the existing way we're doing this, i.e., how successful is the invention, is actually very prone to initial conditions and all these things that we see in complex systems, positive feedback. So you're able to use complexity science to point to the unreliability of the current method, but then also use complexity science to say, but we can understand the concept of inventiveness by taking a network approach, and we understand how networks work because we understand both network science and complexity science. I mean, that's really
Exactly.
powerful stuff. So where does this, the other area you talk about is AI regulation. So how does this fit in with AI regulation? What are the complexity lessons there?
Okay, so I will give you only one example, and of course, this is a very hot topic, and much of the legal world or the world that is interested in law and technology is thinking about this right now, and there's a heated debate. How should we regulate AI systems? What is the right time to regulate them? there's a lot of uncertainty, and the landscape is constantly changing. And one approach that the European Union, for example, adapted in its Artificial Intelligence Act, which is the, I think, most comprehensive effort to regulate artificial intelligence to date, is is to focus on what they call high risk AI systems and subject those high risk AI systems to stricter regulatory requirements and inspection. So the Act tries to define what are those high risk AI systems, and the approach is to identify risky fields. So, for example, systems that are deployed in the health industry or in education systems or in the judicial systems would be considered high risk. But if we look at this again through the lens of complexity and specifically through this emerging new strand in complexity that studies networks of networks, like the relations between complex systems, then we understand that networks and systems do not operate in isolation. Usually, they are connected to other complex systems, and sometimes the vulnerabilities and the failures can percolate from one complex system to other complex system and lead to new vulnerabilities, even to cascades and catastrophes eventually. So, the most common example is from Italy 20 years ago, a power surge that led to the failure of part of the internet, and this part of the internet was supervising another part of the electricity system. So the failure sort of percolated back and forth between the system, eventually collapsing the power system, the internet, the telecommunication system, the health system, the transportation system. So large parts of the country became completely paralyzed. So if we apply this networks of networks mindset to AI regulation, I think we understand that we cannot estimate the risk of an AI system in isolation because these fields are all interconnected. The health system is interconnected to the internet, etc., etc. So what I proposed in one of my studies, for example, is to consider the level of interconnectedness of AI systems as a risk factor when we want to establish whether these systems are high risk or not high risk. So possibly general purpose AI models that are broadly accessible through the internet and can be easily embedded in many other systems are very interconnected. They possibly pose a large systemic risk, even larger than perhaps a closed AI system that is deployed in a sensitive field. So I think this is one example, but I think generally AI has a lot to gain from complexity thinking.
So it's less the. It's very interesting, isn't it? Because it's thinking about the traditional thinking is thinking about traditionally vulnerable systems or high consequence systems. If the AI gets it wrong, the consequences if you're in the legal system, the health system, could be significant. But you're saying it's more complex than that. That it depends on the network structure of the system you're trying to plug it into. Is there any non-obvious ones, Michal, where we would think, oh, there should be no problem, putting AI in that system, but because of the connectivity of that system, it's actually a world of trouble. Is there any obvious examples?
So, the example which comes to my mind is the language models that are easily embedded and adapted to many systems, but are also connected to the internet and to the web and train on this corpus of materials that are on the web. So even errors produced by language models that percolate back into the internet and become part of the training materials and can be exacerbated. And then this mistaken information can, if these models are embedded in sensitive systems percolate to other systems. So we can, hypothesize quite easily how these scenarios may play out. So the I think that the basic idea here is connectivity is something that regulators should look at. And you asked me at the beginning whether the approach of regulators and lawmakers is reductionist or systemic. So here in AI regulation, because now it's sort of a moving target and it's developing worldwide, I think we do have an opportunity to adapt a more systemic mindset for regulation and look at the interconnections and interactions and not just on systems or specific, distinct applications of AI.
And suppose, staying with that point, but going back to a point we made earlier, if you're trying to regulate a complex system, it's adaptive, it's responsive, it's going to respond to, it's going to be fundamentally different after you regulate it than before you regulate it, or before you change the regulations, because it will adapt to the regulation you've just imposed on it and respond. What is the takeaway here, that we just have to have broader, more general rules that regulate, or is there any specific way we can deal with that adaptive nature of the system we're trying to regulate?
Well, I don't think that saying broader rules is sufficiently is sufficient. We should work. We I mean the legal field, but also this involves interdisciplinary work because you have to really understand the systems you're trying to regulate. We should work harder to find more nuanced solutions. So one thing that is proposed in the legal literature is the concept of adaptive regulation, of regulation that is constantly adapting, constantly receiving information, bottom-up information from the field as to the effect of the regulation and adapts itself. We can also think about regulating the short term versus the long term, because we know that in the long term, the unpredictability of complex systems is much more likely to manifest. It's much more difficult to predict the long term than the short term. So if we have a choice between long term and short term regulation, perhaps in some cases, I should prefer the short term rather than the long term. And I think in general, the message should be we should be more humble. I refer to law policymakers. It's not that we're going to get get the legal structure right, and that's it, and we can forget about it from now on.
And is there any? I mean, this concept of adaptive regulation is really fascinating. Has that been done anywhere yet?
Um, I I I'm not sure. I'm not sure
Not
at the
sure. Yeah.
moment.
I
I'm not
mean,
sure.
it
I'm
it
not sure, but it's been discussed. It's been discussed, and scholars have suggested it in the context of environmental law, because the environment is really one of the paradigm examples of a complex system, and the consequences are as we know, are very, very significant for humanity. So it has been proposed in the context of the environment and in other contexts too.
I mean, it's interesting, isn't it? Because there's obviously a political dimension to it as well, in the sense that politicians do like to be able to say, yes, when we put in this regulation, it will absolutely work and will give us the change we need. And I mean, trying to regulate a complex system is the very opposite of that. As you say, the humble, you got to be humble, because the certainty is the one thing we certainly don't have. So there must be a really interesting intersection between people who are actually writing policy and writing the law from a view of, I'm trying to regulate a complex system and I know it will adapt and respond, versus politicians who may want much more certainty of the outcome. That disconnect must be interesting.
I agree. I think it's an interesting thing to look at. I don't know if anyone has looked at this particular aspect. But I don't want the message to be pessimistic, like, oh, we can do anything and we cannot anticipate anything. I think complexity does, at the state of these science today, does give us, as lawmakers and policymakers and legal scholars, a set of tools that can be very, very valuable, even if we cannot solve all the problems of effective regulations, even if we cannot completely take the unintended consequences out of the way. But just understanding exponential diffusion, self-organization, spatial clustering, fractals, and just having the methods of network science, agent-based modeling, etc., is very, very valuable, and we can improve specific laws in many areas using this toolbox. So I'm rather optimistic at the potential that complexity has for the law, even if we can probably not completely eliminate the unpredictability.
So if we go to the perspective of a dispute and a judge or an arbiter trying to make a decision on a case, where does complexity science come in there?
So until now, we spoke about how complexity can be relevant for regulators and legal policymakers, and now you're interested in the perspective of the judges or the arbitrators. So let me let me start by stating perhaps the obvious, which is that judges have to decide specific cases based on specific facts, circumstances. And so we have to be humble and realistic here in the sense that some of those cases may not be strongly related to complexity, right? So for example, when a judge has to decide on the punishment of an offender in a criminal case, they have to focus on the circumstances, of the case, the offender. So this is a rather reductionist analysis, and rightly so. So complexity is not this magical solution to all legal cases. But I do think that in some cases, understanding the principles of complex systems theory could help judges and courts reach better decisions. So one type of cases is the interpretation of the law. So the courts often, especially in common law jurisdictions, have considerable discretion in how to interpret the law. And if we go back to the example which I mentioned earlier, patents non-obviousness analysis, so the use of commercial success as a proxy, as an indication for non-obviousness, was actually introduced by the courts in case law in the United States, in the United Kingdom, in other countries. So it's not written in the law itself, it's an interpretation of the courts. Now, suppose the courts are now familiar with the principles of complex systems, and they can now recognize that the relations between quality, certain quality, technological ingenuity, and commercial success are nonlinear because of preferential attachment, because of sensitivity to initial conditions, etc., etc. So this may not be such a good proxy. So these complexity-informed judges can now reconsider the use of commercial success as an indication for patents non-obviousness and perhaps give it less weight in their decision whether an invention is or is not obvious and deserve or does not deserve a patent. So this is one example, and we can apply a similar complexity lens to other legal questions and areas and find suitable cases where this lens can inform the interpretation of the law. And another second category of cases where complexity can inform decision makers concerns the evaluation of certain evidence. And here I would like to return to the pandemic examples and this distinction between linear phenomena or relatively stable phenomena and nonlinear collective phenomena. So often courts have to decide whether certain actions taken by the state or by the municipal authority are legal, actions that impose certain restrictions on individual liberties. And under ordinary circumstances, the state would need, or the authority would need to convince the court that there is a serious risk that they attempt to prevent. And in order to do so, they would have to prove it, to produce specific high quality evidence. And the court would tend to assume that if there's no evidence about the risk, if there's absence of evidence, then this is actually good evidence that the activity is not that risky. And often courts would also use averages to get a sense of the risk. So suppose the state decides to close a certain road because it thinks it's prone to accidents. So if the court is presented with data about the average number of accidents in the past 10 years in this specific road, this could give the judge, under ordinary circumstances, a good idea about whether the road is risky or not risky. If there were no accidents whatsoever in the past, this is an indication that the risk is probably not that high. But when we are moving to the world of collective phenomena such as pandemic that diffuses exponentially, these conventional ways of evaluating the evidence may not be so useful. Because we know that in complex systems, averages can be misleading in the sense that they may not provide us with a good indication of the qualities of the system, of the magnitude of the phenomena, of the risk. So, for example, the average number of cases, of COVID cases in the United States during the first 8 weeks of the pandemic was something like 63 or 65 cases per day. So relying on these average for evaluating the magnitude of the problem could have produced, or maybe did produce, completely erroneous predictions regarding the scope of the problem and the risk. And also the assumption, the ordinary assumption that the absence of evidence is actually evidence of low risk could also not hold in the case or in the face of exponential diffusion. For example, courts in the United States had to decide during the pandemic whether certain limitations imposed by the state, by New York State, on churches and synagogues and the houses of prayer were illegal. And in some of these decisions, the court said there were no reported cases of infections in this specific venue. So implicitly, it's safe to keep it open. But if we are sensitive to the dynamics, to the diffusion dynamics in complex systems, we can take a close look and see that during the relevant period in question, the overall number of cases in New York State was very, very low because this was after a lockdown. So this absence of reported cases, which impressed the court, did not in fact reflect very meaningful knowledge, very meaningful information for deciding the case. Because of course, once the pandemic diffuses widely, the risks also arises very quickly. So in case of nonlinear diffusion, the interpretation of this type of evidence should be, let's say, hypersensitive to the stage of the diffusion. And so, more generally, I think this implies that in the world of collective phenomena, specific and distinct data cannot always provide the courts with the meaningful knowledge that we're seeking. And sometimes, perhaps counterintuitively, the general evidence about the common traits of complex systems, about the general exponential diffusion of patterns, about the spatial fractal diffusion patterns, this general evidence can be more relevant for a judge that needs to assess a certain risk in order to make a decision about the legality or the illegality of certain means. And of course, this is not just relevant in the case of pandemics, but with respect to other collective phenomena. So, for example, there are certain studies suggesting that certain aspects of environment or of climate change may also be diffusing in a nonlinear way. So courts trying to assess risks, especially in these systemic environments, who are familiar with complexity, should be able to distinguish whether we are in the linear ballpark, where the traditional methods of evidence are valid, or in this nonlinear ballpark where we have to adjust the way we look at certain evidence. So
So that
these are some examples.
so that's really interesting. Because, I mean, applied to evidence, that makes so much sense. The bit I hadn't thought about before, though, which is fascinating, is where you started there with that the evolution of the law has brought us to this point, particularly in common law. And are you saying that some of the precedent that judges would use to make decisions in law, that they may have been fine for, shall we say, linear systems or simple systems in the past, but when you start trying to apply some of those concepts, some of those legal concepts to complex systems, the law sort of itself has to be able to evolve to deal with the fact that it's now talking about a complex system.
Yeah, it is related to our previous discussion of the law as a complex system that tries to regulate complex systems. And fortunately, the law, especially the common law, I think, it has this internal adaptability. So if part of the law is sort of judge-made law, especially in common law systems, then this allows the courts to adapt rather quickly to certain elements that require adaptation because of or as a result of the realization that certain complex system traits are at play here. But again, there's no one size fits all, menu prescription to this. It really depends on the actual facts and circumstances of each case.
Yeah, and it is interesting, isn't it, that when the law understands concepts and complexity science, as you say, that applies, in the dispute side to how they think about evidence, but also how they think about the law itself and its applicability and to the problem they're trying to work through at the time. You teach law students. What is it like teaching complexity science to law students?
So, yes, for the past 10 years or so, I've been teaching several courses, seminars on different aspects of law and complexity, both at the Hebrew University with my colleague, Professor Malkai, and at NYU now with my colleague, Professor Katvin Strandberg. And the idea is not to make law students experts in, physics or system biology or sociology or any other discipline underlying complexity theory, but to present them with the basic principles of complexity and also with the basic methodologies used in this field to study complex systems, so network science and agent-based modeling and mathematical diffusion models and fractals, and to give them some examples of how these principles and methods could be applied to analyze, to solve, to inform legal problems, both at the level of policy making, also at the level of the courts that we discussed, and also at the level of how to design legal rules and how to make use of the understanding of the law itself as a complex system. And I think one of the most gratifying experiences for me in teaching law and complexity is to see how quickly the students grasp these principles, apply them, and often propose new applications of complexity to legal questions which we have not thought about. So, for example, this semester we had students that applied complexity to tax law or to the decisions of courts in China or to image trafficking, et cetera, et cetera. So this is a very gratifying experience, as I said, and another way for diffusing this paradigm of law and complexity.
And just to finish, you're working on your forthcoming book. Tell us about the book.
Okay, so I have a forthcoming book in progress
Yep.
that is titled Law and Complexity, an Introduction, that would be forthcoming with Cambridge University Press. And the book is structured in a way similar to what I described before. So I introduced the complexity theory in a way that is accessible to law and policymakers, sort of a complexity 101 for law and policymakers, the principles, the principal methods, and then I discuss a series of case studies in order to demonstrate how complexity can be applied to inform legal policymaking, to inform legal decisions, and to inform the understanding of the law itself, and in general to design or to align the law with the realities of the world, and to reach better better legal rules and policies that would better handle the great social challenges we're facing.
Michal, thank you very much for being on the show.
Thank you, Sean. My pleasure.